Now back to Inside Real Estate. Here's Mike the Realtor.
Hey, folks, we're back to the house. Inside Real Estate, Mike Kruziniga, InsideRealEstateRadio.com. InsideRealEstateRadio.com is the website. Hey, time for our legal segment. From time to time we get expert legal analysis of the latest and greatest in legal news out there. And so we have our resident expert, Perry Cockerell, here in studio live. His website, perryjcockerell.com, perryjcockerell.com. And, of course, also author of the recently released A Private War, which we discussed recently on the show. It's available on Amazon.com. Excellent book, A Private War. Perry, how's it going today?
Thank you, Mike. I'm glad to be back. Thanks for the plug on the book, too. I was not expecting that.
Well, yes. Well, it's a great accomplishment, and I really enjoyed our segment that we talked about on the show recently about the book, and hope everybody catches that segment, and I hope they catch the book. It's on Amazon.com, and but I know we got a lot to get into here, so we've got some cases that. Some things have totally changed. A couple shows back you were on talking about some things going on, and some of those things have changed. So give us the latest and greatest.
I will, and these are hot off the press, believe me. For those who were listening last month when I spoke about those home equity loan cases, one of them was an actual forgery where the wife had even transferred it during the divorce proceeding to her husband, and then the other one involved a wife that did not sign the note. Her husband had signed the property and secured the homestead, and he was awarded the property. Both of those suits, the wives, I refer to them as ex-wife regret cases, but they're symbolic of what they call non-compliant home equity loan cases where violations have occurred during the process of the loan, and one of them could be, let's say the loan was more than 3%. You cannot have a home equity loan that has that violation. The second one would be, what if the borrower gave a home equity loan on agricultural property? Texas Constitution says you cannot do that. Let's suppose you cannot have a second home equity loan on your property. The Constitution says you can only have one, but what if you had two? Now, what happened was, what is the rule in these kind of cases? The law says the borrower is to give notice to the lender to cure, and the lender has 6 ways to do that. In the old days, prior when the Constitution came out, the lender was at the mercy of the borrower and could not cure, and it could result that loan would be forfeited. Well, in 2003, amendments were given so that the lender could cure these, and there's 6 of them. So there's many ways to cure these kinds of what they call constitutional violations nowadays. But what was not answered, or at least what was not provided in the Texas Constitution, was what's the period of time for the borrower to give notice to the lender so that the lender can cure? And the Constitution provided 60 days notice for the lender to do that. In the prior constitutional amendment, there was no time. It was reasonable time. So this was changed. Now, the Fifth Circuit Court of Appeals in New Orleans is a federal appeals court. It doesn't decide federal law in some respects. It does decide federal law. It gives what they call a guess. And they do that if the state courts, such as the Supreme Court or the appellate courts, have not answered a question, or if it's not provided in the Texas Constitution. The Texas Constitution did not have what they call a statute of limitations for these what are termed invalid loans that do not comply with the Texas Constitution. So the Fifth Circuit, when it gets questions like this, normally gives what they call certified questions to the Texas Supreme Court. And they ask the Texas Supreme Court to answer what is Texas law in these cases. And the Texas Supreme Court really does. And they do that quite often. And they do that in very difficult cases where they do not want to decide a substantive issue like that would have statewide importance. Now, for some reason, in this case called Priester that came out in 2013, they did not do that. They did a guess of what they thought Texas law would be, and they decided that when a loan doesn't comply with the Texas Constitution, the borrower has 4 years to notify the lender from the closing And then if the borrower does not do that, the borrower loses that ability to invalidate that home equity loan. That was their decision. And it was based on terminology of whether a loan was voidable or void. And they believed, based on a Texas Supreme Court case, that loans that did not comply with the Texas Constitution were voidable. And therefore, since no action was taken within 4 years, the borrower could not file suit, like an action to quiet title, to invalidate that loan. Now, the Texas appellate courts, such as the Dallas, the Houston, Texarkana, began analyzing that decision, and they said that this is good analysis. We agree with that. And they began to adopt that rationale, even though it had not been adopted by the Texas Constitution, and the Supreme Court of Texas had not answered that question. And so it became kind of, I would say, settled law for at least the last 3 years. Now, for the lender, this was a good thing. And title insurance companies, this was a good thing. If this loan could be made and nothing happened for 4 years, this was like a clean bill of health. This loan is good. The borrower is not going to do anything anymore. And so lenders really like that. And
yes,
title insurance companies like that because it prevented.
They don't want anything coming back.
Particularly 4 years later. And some of these cases were 9 years. I had one that I litigated with 9 years later. They come back and say, well, you didn't give me the loan. I didn't sign this at the closing, or you didn't give me this document. Some of them are difficult. You have to go back and, well, anyway, the Texas Supreme Court said they were not persuaded by those types of arguments, I'll have to say they called it right in this case, and I do. However, it's a 6-3 decision. It has a dissent from Chief Justice Hecht. Chief Justice Hecht is substantial. What he says really goes, I think, for the most part. And he's on the dissent on this. But it comes down to the Constitution that says no lien on the homestead shall ever be valid unless it secures a debt described in this section. So that terminology, shall ever be valid. But remember what the Fifth Circuit said, that if it's non-compliant, then it's voidable. Okay, voidable is not the same as shall ever be valid, which is right out of the Texas Constitution. So the effect of the Fifth Circuit opinion meant that, for example, a 3% loan, if it's in excess of that, it would still be valid. The lady that didn't sign the note, she lost because she didn't file suit. The lady whose name was forged, she lost because she didn't file suit within 4 years, and she transferred the property. The two cases where agricultural property was taken, they lost because they didn't bring suit. And then the most recent one, a second lien home equity, clearly the Constitution says you can't do that. They lost because they didn't bring suit within 4 years. Now, the Texas Supreme Court says that there is no statute of limitations on that the plain reading of the Constitution necessitates a finding that the liens securing these non-compliant home equity loans are not valid before the defect is cured. And so the court held that the Constitution does not support a holding that non-compliant home equity loans are merely voidable. So they've rejected this void type definition of how to, which is really in Texas common law. So the Fifth Circuit looked at Texas common law, and they looked at a Texas Supreme Court case that they thought suggested the void rule. So the Texas Supreme Court said the Texas common law doesn't preempt the express Texas Constitution. So the court said that a non-compliant home equity loan is invalid until it is made valid. And otherwise, it would just permit lenders to ignore the Constitution and foreclose on unwitting borrowers who do not realize that their home equity loans violate the Texas Constitution. Mm-hmm. And it would also mean that these loans are just validated because of the passage of time.
Right, the 4 year.
And then I think this was a good argument they pointed out in the majority, is that if you know that the Texas Constitution, when it comes to the home equity provision, it is a long, labyrinthine type provision is very difficult for the courts to maneuver. It is overly complicated, and it reads like a closing statement you would give to a closer when you're closing a loan. Normally, if you look at the Texas Constitution, it says that you can have a lien on a homestead if you want to buy it. It doesn't tell the closer how to close that loan.
Mm-hmm.
You can have a mechanic's lien on a homestead, but it doesn't define how to do that mechanic's lien, and it certainly doesn't put the terms and conditions of those mechanic's lien in the Texas Constitution. But when it comes to the home equity lending, the entire notice, the disclosures, the substantive rights, the terms and conditions, which have to be in there, such as the notices of the 12 days, the right to reject, the loan to value, there are labyrinthine. They are in the Texas Constitution. A Texas Constitution is not supposed to
have all that.
Read that like that.
Yeah, no.
That should be left to the legislature. All it needed to say is the Texas legislature is authorized, or home equity loans are authorized, or a loan secured by a home equity loan.
Yeah, and the details are up to,
Let the Texas legislature set out what the details were. Well, the only reason it's like that is because they'd been pushing for home equity lending for years. And so the only way to get the voters to approve it was to make sure that the lenders would be punished harshly if they didn't comply with the loans. So they made them so that the borrowers are not personally obligated, and they made it so that the loan could be forfeited as a punitive measure to the lender, because they were really concerned that lenders would go out, get liens on home equity loans on the properties, and then would foreclose them, and borrowers would be losing all their homesteads. Mm-hmm. That was the rationale. And I think we're way past that now. People know, people want a loan. People don't want to wait 12 days. They realize if you don't pay it back, you're going to lose your home.
Exactly.
So I think the whole Constitution needs to be amended, but I do think that the Supreme Court called it right on this one, because it was not fair for borrowers to lose their home or their ability to have that loan cured. At the same time, though, there has to be this 4-year issue. It needs to be addressed. But the Texas Constitution didn't place a statute of limitations in it. It didn't refer to the 4-year at all. So that might have meant that they didn't intend for non-compliant issues to be raised, to be foreclosed after 4 years. None of those terms and conditions say anything about that. They do not say that if you do not assert a violation within 4 years, you lose your rights, and therefore a loan on property which is not eligible, you lose that. None of that is in there. But I do hope.
So moving forward, then, if a loan is invalid, there's going to be no statute of limitations. A borrower can come back on that at any point. Let's say it's a 30-year loan. At any point, for any reason, if there's something of issue, if it's invalid, there's no statute of limitations at this point now.
For an action to quiet title in order to remove what they call an invalid lien. Now, what that means is the borrower can give that 60-day notice at any time during the term of the loan. There's no limitation on a borrower on that anymore. It's not 4 years, as the Fifth Circuit said. Now, it could be, if it's a 10-year loan, it could be in the 9th year. The lender has 60 days to cure. So the lender has an obligation to cure within 60 days, but the borrower does not have an obligation to provide notice within 4 years and look at the loan file and figure out if there's an issue. It's from the time of the closing. So, and I don't want to take a position on all that. Those things needed to be in the law itself when the law was passed or the Constitution was passed. And it's something that legislature has got to do something about the statute of limitations, not in this case, but in other cases where they're not accepting cases under some types of 2-year or 4-year. And in some cases, in one case, they denied hearing a limitation case last month where the party that sued didn't know who harmed them. They weren't even damaged yet until 6 years down the road. The law and the rules of procedure do not say what do you do in this case. The Texas Supreme Court says, well, you have to sue within 2 years of the injury. You have to sue even if you don't know who injured you, and you don't even if you haven't even been damaged yet.
Which is and how is that possible?
Well, it's not under the home equity. That's under it's under a different other types of like breach of fiduciary duty, breach of contract, things like.
I mean, I can kind of understand this. I mean, it's on the borrower side. I mean, look, the closing packets to purchase a home and to refinance for a home equity loan, I mean, they're a couple inches thick. So, I mean, the average borrower, they just sign it all, because if they don't sign it all, they don't get the house or they don't get the home equity loan. It's not like you can really go and say, I'm not going to sign this, or, I mean, I suppose you can bring in an attorney and maybe do some additional work, but that's going to take a while to get through it and get the loan. So on the borrower side, I can kind of understand that you may not know something until 5 or 10 years down the line, but to give the lender only 60 days to cure, that's certainly putting them in a tight spot. Of course, they wrote all the paperwork anyway. So
it sets out
they should know what it says.
Cure. They set out the way to cure, and the way, if you can't cure, then there's this last option. You can offer to refinance the loan and pay $1,000, and that's going to be a segue into the next segment. But I also point out, let me tell you, one of these agricultural loans, the borrower went in there. In that case, she forged her husband's name to his will when she's in the hospital. He dies. She then probates his will, conveys the property to herself, takes out a home equity loan, and says that it's not agricultural, and offers to remove the agricultural designation. And so they go through the closing on the express purpose of doing that. Except they somehow didn't get it actually done with the appraisal district, so it's still designated agriculture at the time of the loan. Now she takes bankruptcy, says, oh, it's not agricultural anymore, it's homestead. And the court agrees with her and forfeits that loan and says, well, you should have known it was designated as agriculture at the time of the loan. Yes, it was, but that's because she was converting it to exempt, and said she signed an affidavit that said that it was not. Okay, the court says, well, it's too bad you knew it was. So the question was, it was designated at the time. That's a clear fraud case.
Right.
Okay, that's where I side with the lenders and think this is not right. Borrowers shouldn't come back, change their mind. That's the kind of thing. It's got to be changed. It's got to work fair on both sides.
Both sides,
here.
I agree. Absolutely.
That was totally unfair. That's a bad. Never mind. I won't comment on that decision. But let me move into the next one. What happened?
And we're running a little short on time here too. We got about a minute and a half.
1 minute. What happens if? Let's give you this. The loan's paid off under the Constitution. You're supposed to deliver the lien back, the note back, deliver the lien back to the borrower. What happens if the note's paid off completely, and then the lien is not delivered back to the borrower, but the lien is filed of record? The Constitution says you have to deliver that loan, that release of lien back to the borrower. What happens if the lender does not? Well, in the next case Supreme Court issued was a certified question from the Fifth Circuit. The borrower paid the note off, but the lender filed a release of lien of record, but under the Texas Constitution, they're supposed to provide a copy of that note and that release of lien to the borrower. They did not within 60 days. They said nothing. They did nothing. Borrower files suit to say, oh, you give me all my money back. If you forfeited, it's because you didn't deliver the loan back. This is the danger of
within
these
60 days.
And that's the problem. What happens if you don't cure? What if you cure on the 61st day? Well, anyway,
I want all $500,000 I paid to you over 30 years
that's
back.
Exactly
right
what they were trying
now.
to do.
Plus,
well,
I was damaged.
The court said no. The court said no. That's the forfeiture remedy depends on whether you're foreclosing and whether you fail to comply with the 6 corrective measures. Here, the loan's already paid off. Paying $1,000 and offering to refinance a loan that's paid off makes no sense. So none of the curative measures apply. It doesn't apply post-origination. It applies origination. So therefore, they said no to that.
Wow.
So forfeiture is not necessarily a
folks. Hey, and we've got so much more to talk to you about on this for sure. Folks, come on back next week. 8 to 9, Inside Real Estate. We've been talking to Perry Cockerell. Hey, we'll be seeing you next week. Have a good one.